Hello, I'm Marcus Boston. Quick video today. All right, so you feel that your child's brain injury at birth was due to something that your OB failed to do. And in your research of finding out about your OB, you find that the doctor has been sued in the past for medical malpractice. And now the question is, can you use that fact, the fact that your doctor has been sued before for medical malpractice, can you use that in your child's birth injury trial? You want to know the answer to the question? Stay with me as I share with you this really important information. All right, so before I answer it, I want to help you understand how we prove these types of cases, how we prove birth trauma cases or birth injury cases. These cases, they really stem from an area of the law called torts and negligence, all right? And so there are going to be certain elements that we have to prove. Now, I just shot a video in which I talked about something kind of similar to this, but the question in that video was, you find out that the OB has insurance and you want to use that fact in the trial, all right? And so the fact that now you find out that the OB has been sued before, can you use that? Some of the reasoning in the video is going to be the same in regards to this issue, but I want to make sure that you understand, if you step back and understand how we prove things, it will probably make a lot more sense. All right, so remember I said this is torts, this is negligence, there are elements that you have to meet. All right, and one of the big ones is that you have to show that there was a deviation or that there was a departure from the standard of care that was owed, and a departure from that standard is what has caused the injury or the harm to your baby. As the plaintiff, you have to be the one to prove that. The one, if you bring in the case, that's what you have to prove. And you prove that using medical experts. You use medical experts to do this. Now, remember, the defendant or the defense, they're going to be using medical experts too. And their medical experts are more than likely going to say either there was no departure from the standard of care, in other words, that the doctor, the OB, did everything that they were supposed to do. They stayed within that standard of care. Or they may defend and say, well, the cause of the injury, it had nothing to do with the OB or the doctor, had nothing to do with that. There was some other type of outside factor is what caused the injury. So the defense, they're going to defend the case too. Now, going through all of this, the jury is going to have to make a determination as to the issues of the case. They're going to be advised by the judge as to the law and to what law to apply to the facts. Now, remember I said standard of care, causation, departure from the standard of care, all of these things, these are all issues that the jury are going to have to figure out. Now, where in that analysis do you think the fact that the doctor has been sued in the past, where does that fit in the current set of facts? Where do you think that would fit in? All right, the simple answer is going to be it does not fit. What the doctor did in the past in another case, a lot of times the argument is going to be that is not relevant as to what the jury has got to decide under these set of facts, under the case at bar. So the short answer is going to be that in general, no, you're not going to be able to bring up the fact that your doctor was sued in the past and try to bring that into the current case. We want juries to be able to assess and to be able to decide cases based on the evidence presented to them in the current trial. That's what we want to do. And the judge that's going to be presiding over the case, they have to follow what we call the rules of evidence. And so if there's going to be any type of evidence that comes in or that's going to be submitted to the court, and that evidence is irrelevant, or that evidence is going to cause confusion of the issues and is going to confuse the jury, then the judge is probably not going to let that evidence in. So the purpose of today's video is to help you understand a very critical and important issue in these types of cases. The fact that because a doctor has been sued in the past, you're not going to be able to use that in general in your current case. If you have more questions about what's going on, maybe you're here today because your baby has suffered an HIE diagnosis at birth. and you have questions about that, you want an investigation done as to maybe what was the cause of this. And so that is the purpose of today's video, to help you get insight into some of these critical issues. If you want to speak with me further, there's a telephone number on the screen. Go ahead and pick up the phone and call me. I talk with families all the time about HIE, the outlook for HIE, challenges that their baby may face going into the future, subsequent CP diagnosis if that's present, MAS, brachial plexus injuries. This is what we do. We talk with families and we help them when it comes to birth trauma or birth injury cases. All right, that's going to be it for today's quick educational video. One more thing I want to make sure that you understand. If you call me and you are not in the state of Maryland, I practice law here in the state of Maryland, you got to understand that we have to use what we call co-counsel or local counsel, an attorney in your state to help with the case if this is something that we think that we can assist you with. I just want to make sure that you understand that co-counsel thing, because this video is on the internet. That's going to be it for today's quick educational video. Again, I'm Marcus Boston, and I'm one of the childbirth injury and medical malpractice attorneys practicing law here in the state of Maryland at Boston Law Group, LLC. We will see you next time. Take care and enjoy the rest of your day.